Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about Medicaid recovery from your estate upon a Medicaid recipient's passing. But before I do, I invite you to schedule a free strategy session with me at eldermeeting.com. Okay, so it's a common inquiry that I get when we are doing Medicaid planning. We know a person has medical needs that would benefit from Medicaid, and we are shifting some assets and looking at their incomes and making sure that the person qualifies for Medicaid financially. And when we do that, many times they and their families are concerned about Medicaid estate recovery. They heard about it. They heard that Medicaid will want to get paid back for all the value of the medical services that they provided you. And they're just really concerned about their legacy and what they're going to be leaving their family upon their passing should they partake in the Medicaid program. So today I wanted to make sure that you understood what some of the limitations and exceptions there are to Medicaid estate recovery, at least here in the state of Florida. Number one, Medicaid can only recover from your probate estate, meaning assets that are subject to the probate proceeding. So if you have moved and sheltered your assets in such a way that they are not subject to probate, then Medicaid will not be able to recover from those assets. Think pay on death beneficiaries for your bank accounts and things of that nature. Also, Medicaid does not engage in recovery until the Medicaid recipient has passed away. So you don't need to worry about Medicaid coming and knocking on your wife's door asking to be paid while you are still receiving nursing home care. They would never be seeking recovery until the Medicaid recipient has passed away. There is no debt created if the Medicaid is paying benefits for someone who's under 55. So if you're a person who's under 55 and receiving Medicaid benefits, and there's no debt that's being generated during that time of service for the benefits that you're receiving. Also, Medicaid will not enforce debt in a probate when the Medicaid recipient dies, when they are survived by a spouse, if they are survived by a child that's under 21 years of age, if they're survived by a child who is blind, if they are survived by a child who is permanently disabled, considered by Social Security. And when we say child who is blind or permanently disabled, they don't have to be under 21. They could be an adult child. Also, Medicaid cannot recover from your estate from exempt property. So think of your homestead here in Florida, also your family car. Those are considered exempt pieces of property. So even if at the time of passing the title was held in the Medicaid recipient's name alone, the court will deem them to be exempt properties, and Medicaid will not be able to recover from the value of those assets. And lastly, Medicaid cannot recover if it would result in an undue hardship to the qualified heirs. So if Medicaid's recovery results in an undue hardship, they simply cannot recover. So I hope that this information has been helpful to you as you consider all the implications of what receiving Medicaid would look like for you or your family. If it has, I ask that you like and share this video with others. And as always, you're welcome to join me for a free strategy session at eldermeeting.com. Thanks for joining me.